to the channel Law and GK. Here we are going to discuss the previous year papers of judiciary and other legal competitive exams. And right now our Uttarakhand Judicial Services previous exam series is going on, and today I will be discussing Uttarakhand's previous year paper of 2014 and 15. So without further ado, let's start with the part 1 of the paper, that is general knowledge. So here the first question is, which of the articles of the Constitution of India empowers the President to appoint acting Chief Justice of the High Court? This question needs no explanation as it is very simple. Article 223 talks about the appointment of acting Chief Justice of High Court. Now the second question is, who shall be the chairman of the Council of States in accordance with the provision of the Constitution of India? So according to the provisions of Constitution, the chairman of Council of States should be the Vice President of India. Now the third question is, Andhra Pradesh Reorganization Act was passed in the year 2014, but right now in the year 2022, this question is not important. This was asked, I guess, just because it was 2014 and this question was related to current affairs of that time. The next question is, the Lokpal and Lokayukt Act was enacted in India in the year 2014. The next question is, the National Food Security Act was passed in the year. It was passed in the year of 2013. Question number 6. Territorial water limit of India is 12 nautical miles. Very simple question of international law. Okay, now the question number 7th. Which one of the following rules is related to extradition? So here it is asked about the rules of extradition. So before coming to the rules, one must know that what is the meaning of extradition. In Hindi, extradition is called pratyarpan. Okay? So what is its meaning? That when an individual who is charged with a crime in one state flees to the another state, then the state requests the other state where the individual has fled to send him back so that he can stand a trial for his crime. So basically, in simple terms, the state asks for his fugitive criminal to be sent back. Okay. And extradition and asylum are generally confusing terms, and so you must understand that in asylum, person is basically, the criminal is basically afraid of being prosecuted in his home state. So that is why he runs away from his home state to some state where he can get some protection. Okay. And this is not the case in extradition. Now one more important question that can come, the difference between extradition and asylum was discussed in which case, which was Colombia versus Peru, 1950. Okay, so the difference of asylum and extradition was discussed in this case. And one more term that is related to that extradition and can be confusing to you people is expulsion. This can also confuse you. So extradition is when a country requests for his fugitive criminal to be returned to that state, and expulsion happens when an individual violates the immigration laws. Okay, so then he is expelled. Now the difference of expulsion and extradition was discussed in the case of Hans Mueller of Nuremberg versus Superintendent Presidency Jail, Calcutta and others, 1955. Okay, the difference of expulsion and extradition was in this case, Hans Mueller of Nuremberg versus Superintendent Presidency Jail, Calcutta and others, year 1955. Okay, so the meaning of extradition is clear, I guess now. Now, in extradition, there are certain rules which the government has to follow. These rules are rule of number 1, treaties. Okay, then the rule of speciality, then rule of double criminality, and there is one more thing, that the government has a right to reject the request of extradition. Okay, and in India, the rule of extradition is governed by the Extradition Act of 1962. All right, so what should be the answer here? Option C is the right answer. Now, who defined neutrality as the attitude of impartiality adopted by third states towards belligerents and recognized by belligerents such attitude creating rights and duties between impartial states and the belligerents? So the right answer here is L. Oppenheim. L. Oppenheim, he defined neutrality. He has given this definition. The next question is, which of the following is not a specialized agency of United Nations? So United Nations specialized or agencies, UNESCO, yes it is. ILO, International Labour Organization, this is also specialized agency. But Economic and Social Council, this is not a specialized agency. So guys, as you know that United Nations was formed to solve the economic, social, cultural and humanitarian problems through international cooperation. Okay, and for that purpose a number of specialized agencies have been set up to achieve the goal of solving such problems. So the option is this, Economic and Social Council, because it is not the agencies. Agencies are formed in United Nations with the help of this council. Okay, so UNESCO and International Labour Organization are specialized agencies. These specialized agencies जो हैं are formed by Economic and Social Council under Article 57 and 63 of United Nations Charter. Okay, some of the specialized agencies and even the full form can be asked of them. So for example, Food and Agriculture Organization, International Civil Aviation Organization, ICAO, and International Labour Organization, ILO, okay, and International Monetary Fund and UNESCO. So sometimes its full form also asked, and like that, WHO, World Health Organization. Now the next question is also related to United Nations, on whom the members of United Nations confer primary responsibility for the maintenance of international peace and security. So security, international peace and security, so Security Council. The right answer is option A, Security Council. Now the next question is, Vienna Convention on Diplomatic Relations 1961 came in the force on which date? So the right option is option C, 24th April 1964. The next question is, who made the observation jurisprudence is lawyer's extraversion? So this term was given by Julius Stone. Okay, Julius Stone gave this term. Next question is also related to jurisprudence, which is not a jural correlative in the following pairs: right, duty, immunity, disability, liberty, no right, power and disability. So here the right answer is power and disability, but you must know the formula to learn these terms. Jural correlatives should be learned like this: CLPIDNLD. Claim, liberty, power, immunity, duty, no claim, liability and disability. So here the claim or right, you can say right, whichever option you want to use here you can use. So jural correlative, so right and duty. Okay, now liberty and no right. Okay, power and liability, and immunity and disability. So all are right and duty, the first option. Okay, now liberty and no right, liberty and no right, second thing. Immunity and disability, immunity and disability, okay, and power and disability. So confusion is creating here in these two options, but as I have given you this formula, so there is no confusion now. So the right answer is power and disability. This is not the dual correlative. What is the right dual correlative? Immunity, power and liability. The next question is, the Commission on the Status of Women was established by Economic and Social Council. So there are basically six main bodies of United Nations, and what are they? That is General Assembly, then Security Council, then Economic and Social Security Council, then Trustship Council, then ICJ, and then Secretariat. Okay, so here the question is asked, the Commission on the Status of Women was established by, so this was established by Economic and Social Council. Now, which of the following can enforce the judgment of ICJ, International Court of Justice? General Assembly on a recommendation of Security Council, no. Secretary General, no. The right answer is Security Council on the request of International Court of Justice. Now, the next question is question number 16th. National Human Rights Commission in India came into the force. The right answer is 28th September 1993. Human Rights Commission. Now, the next question. The recommendations of National Human Rights Commission is it binding, or is it advisory, or is it both A and B, or none of the above? So the recommendations are always advisory and cannot be binding. Okay, the right answer is advisory. Recommendations of Human Rights Commission are always advisory. The next question is, the headquarters of World Bank is situated in Washington DC. So for the examination point of view, you must remember the main headquarters of main agencies of United Nations. For example, the headquarters of WHO is in Geneva, Switzerland. Okay, this one is very much important. Then the headquarters of UNICEF is in New York, USA. Then the headquarters of United Nations Organization, where is its headquarters, is New York City, USA. Then United Nations Security Council, UNSC, this one is also in New York. Then International Labour Organization, that one is in Geneva. Okay, UNESCO is in Paris, France. Okay, so you must remember the headquarters of main agencies at least. So question number 18th, which is the headquarters of a World Bank, is situated in Washington DC. So basically most of the headquarters are either in Washington DC or in Geneva or in Paris. Next question is question number 19th. Who among the following was hanged by the British government in regard to the Kakori conspiracy? Bhagat Singh, Chandrasekhar Azad, Ram Prasad Bismil, and Batukeshwar Dutt. The right answer is Ram Prasad Bismil. So let me explain you a little bit about Kakori conspiracy. This conspiracy was basically a train robbery which held in Kakori district. It was a village near Lucknow. Okay. This conspiracy held on 9th of August 1925, and this conspiracy was organized by HRA, Hindustan Republican Association, which later became what? Hindustan Socialist Republican Association. तो HSRA बन गई थी later on. Okay, and the robbery was conceived by Ram Prasad Bismil and Ashfaq Ullah Khan, and they both were belonged to the HRA, Hindustan Republican Association. Okay. Whereas Bhagat Singh and Batukeshwar Dutt, they both set up homemade bombs in a Central Legislative Assembly in Delhi. Now question number 20. On whose recommendation amongst the following the Constituent Assembly was constituted? क्रिप्स मिशन, वेबल मिशन, लॉर्ड माउंटबेटन या फिर कैबिनेट मिशन प्लान? तो राइट आंसर इज ऑप्शन नंबर डी, कैबिनेट मिशन प्लान. Question number 21. Ashok Mehta Committee was related to the center-state relations, economic reforms, Panchayati Raj, and none of the above. Then the right answer is Panchayati Raj. And one more important thing, Ashok Mehta Committee was formed in year 1977, and similarly G.V.K. Rao Committee and Singhvi, both these committees were also related to Panchayati Raj. So basically three important committees are there for Panchayati Raj: Ashok Mehta, GVK and Singhvi committee. Next is question number 22. Power to constitute new states and its determination of boundary vests in option A, Parliament, B, Vice President, Governor, or none of the above. Then it's very simple. New states and its determination of boundaries vests in Parliament. Okay, right answer is option number A, Parliament. But Parliament may by the law. It's in Article 3. Next, who is the chairman of National Development Council? Whether President, Prime Minister, Finance Minister, or none of the above. Then the chairman of National Development Council is Prime Minister. Now question number 24th, very important question. Carry forward rule. Carry forward rule was held as ultra vires in the case of Menka Gandhi, Devdasan versus Union of India, Pradeep Tandon versus State of UP, and fourth is none of the above. Then first you need to understand what is carry forward rule. It is basically when the unfilled reserved vacancies of a particular year are carried forward to the next year. This is carry forward rule and was held ultra vires in the case of Devdasan versus Union of India 1964. Next question is question number 25. Hicklin test under Article 19(2) is related to decency and morality. Hicklin test. So where did this term Hicklin came from? Hicklin test is a term which is commonly used for a case. The case was Regina versus Hicklin actually, and from this case the term Hicklin test came. This test is basically for the test of obscenity, means whether the thing is obscene or not. For that purpose this test is done. Okay, now question number 26. Disputes between states in India comes to Supreme Court under appellate jurisdiction, original jurisdiction, advisory jurisdiction, and none of the above. Then disputes between states, here the term is states, so it comes under the original jurisdiction of the Supreme Court, because the matters related to states doesn't go to High Court or normal courts, they come directly to the Supreme Court, so original jurisdiction. Now question number 27th. Which amendment under the Indian Constitution provides for reservation in panchayats to women? The amendment was 73rd amendment, not 77th, 74th, 75th. No, the answer is 73rd amendment. The next question is, to whom the President of India tenders his resignation? President will give his resignation whether to Prime Minister or Vice President, Chief Justice of India, and the option is Parliament. Then the right answer is Vice President. The President will write his resignation to Vice President, and it is in which article? Article 56(1) Proviso A. Now 29th question. In which organ of United Nations the membership has been enlarged twice by amending the United Nations Charter? International Court of Justice, Security Council, Trusteeship Council, and Economic and Social Council. Then the right answer is Economic and Social Council. Now question number 30. The first meeting of the Constituent Assembly was held on 9 December 1946, 15th August 1947, 26th November 1949, and 10th January 1948. The first meeting was held on 9th December. Don't get confused with these famous numbers. The right answer is 9th December 1946, first meeting of Constituent Assembly. Question number 31. Which one of the following is not permanent member of United Nations Security Council? Then the right answer is Japan. The other 3 are permanent members. Now the next question is question 32. Who was the constitutional advisor of Constituent Assembly? Dr. B.R. Ambedkar, Pandit Jawaharlal Nehru, Shri B.N. Rao, or option D, Rajendra Prasad. Then here it is asked constitutional advisor. The advisor was B.N. Rao. B.R. Ambedkar was the chairman of drafting committee and Dr. Rajendra Prasad was the president. Now question number 33. The present Lok Sabha is 13th, 14th, 15th or 16th. So now the present Lok Sabha is 17th Lok Sabha. Here it is not important what was the number in year 2014, but right now it is 17th. Next question is, which of the following amendment Act of the Constitution provided for the appointment of one person as governor of 2 or more states? Second Amendment, Third Amendment, Fifth or Seventh Amendment? Right answer is option number D, Seventh Amendment. Okay, question number 35. Who amongst the following has drafted the preamble to the Indian Constitution? Mr. Rajendra Prasad, Pandit Jawaharlal Nehru, B.R. Ambedkar or Vallabhbhai Patel? Preamble. Jawaharlal Nehru drafted the preamble. Okay, question number 36. In which of the following subjects India has recently in 2014 signed an agreement with Russia for environment, defense, atomic energy cooperation or health? Then if you guys remember, in 2014 India signed for atomic energy cooperation. Now next is question number 37. In which of the following countries 18th SAARC summit was held in 2014? Options are India, Bangladesh, Nepal or Pakistan. The right answer is option number C, Nepal. Okay, there is a typing mistake here. It is not 8th SAARC summit, it is 18th. So correct it please. And when is the 19th SAARC summit held? 19th SAARC summit was scheduled in Pakistan, Islamabad, but it got cancelled after the attack on Indian army camp in Jammu and Kashmir, which was famously called Uri attack. Okay, so it was then cancelled. Now 20th SAARC summit is to be held in Pakistan, Islamabad, the capital city of Pakistan. Now, important question arises that what is the full form of SAARC? SAARC is South Asian Association for Regional Cooperation. Now, one more question arises that how many countries are there in this SAARC? Then total number of 8 countries are there, which are Bangladesh, Bhutan, India, Maldives, Nepal, Pakistan, Sri Lanka, Afghanistan. Afghanistan is the 8th country which became member of SAARC in 2007. And when was SAARC established? It got established in the year of 1985. Question number 38. In which of the following cases Supreme Court held that an amendment of the Constitution under Article 368 is a law under Article 13? Sajjan Singh versus State of Rajasthan, Shankari Prasad versus Union of India, Keshwananda Bharti versus State of Kerala or Golaknath versus State of Punjab? Then it was said in Golaknath versus State of Punjab, 1967. And all these 4 cases are very important. Sometimes their years are also asked. Then you must remember the years of these particular cases. Then Golaknath versus State of Punjab was case of 1967. Keshwanand Bharti, 1973, very important. Sometimes this question can be asked. And Sajjan Singh versus State of Rajasthan, 1964. And Shankari Prasad versus Union of India, 1951. Now question number 39. Doctrine of prospective overruling was approved for the first time in the constitutional interpretation in the case of Keshwanand Bharti versus State of Kerala, Golaknath versus Punjab, A.K. Gopalan versus State of Madras or Charanjit Lal versus Union of India. Then prospective overruling case, very Golaknath versus State of Punjab. Question 40. The General Assembly of a UN cannot be said to be a world parliament because it cannot legislate the states of the world. Its resolution do not have binding force upon the member state. It cannot intervene in the matters of domestic jurisdiction of any state member, or D, all of the above. All these options are correct. Then the right answer is all of the above. Now question number 41. In which section of the Protection of Women from Domestic Violence Act 2005 the word domestic violence has been defined? Section 4, 3, 6 or 5. The term domestic violence is defined under section 3 of Protection of Women from Domestic Violence Act. Now question number 42. By which Amendment Act Schedule 9 was inserted in Indian Constitution? So Schedule 9 is which is related to property laws came with First Amendment Act. Now question number 43. Where the G7 summit in June 2014 was held? That was held in Brussels in 2014, Brussels. And now if this question similar question is asked, then 2021 it was held in England. G7 summit. In 2022 where will it be held? In the year 2022 it will held in Germany. This is about G7 summit. And what about G20? Then in 2022 it will held in Bali, Indonesia. And in 2021 it was held in Rome, Italy. Okay. Now question number 44. Which convention was related to prisoners of war cruelty and collective penalties and formulated for providing medical and other facilities to the prisoners of war? Option A, Kellogg-Briand Paris Pact, Geneva Convention, Declaration of Paris, या फिर Hague Conference. Then the right answer is Geneva Convention. This convention was actually related to providing medical and other facilities to the prisoners of war. And what about Kellogg's-Briand Paris Pact? This was related to multilateral agreement to eliminate the war in national policy. And this Declaration of Paris Pact ये थी maritime law पे. And the Hague Convention, this was related to conduct of warfare. Next question is question number 45. Who has been awarded by the highest award of Japan, the Grand Carton of the Order of Paulownia Flowers recently? Option A, Mr. Narendra Modi, Dr. Manmohan Singh, Mr. Nawaz Sharif, or none of the above. Here it is mentioned that it is the highest award of Japan. And the right answer is Dr. Manmohan Singh. This award actually is not distributed annually. Okay, these are given till now. It is given only to 24 persons. Out of them, only 18 persons were Japanese and other of them were outsiders. And if talked about the prime ministers or presidents, then Indian Prime Minister Manmohan Singh got it. Now, question number 46. A person convicted by the court may be punished only in accordance with the statute. Is the meaning of which maxim amongst the below? Then the right option is option number C, nulla peona sine lege. Okay, and then meaning of these are also important. The first one is nullum crimen sine lege means one cannot be punished for doing something which is not prohibited by the law. Okay, and option number B, nemo propria causa judex is a debit. Then it is nemo not propria, it is impropria. It's miswritten here. It is nemo impropria should be there. Then no one should be judge of his own case. Now let's come to question number 47. What is the right sequence of the following? United Nations Declarations, Atlantic Charter, Declaration of St. James Palace, and San Francisco Conference. Then the United Nations Declarations, these were held on 1st of January 1942, and Atlantic Charter held in 14/8/1941, and San Francisco Conference 25th of April 1945, and Declaration of St. James Palace, it was held on 12th June 1941. Then correct sequence according to the dates is option number A, 3, 2, 1 and 4. And similarly, if some other names also come, for example, Moscow Declaration, that was held on October 1943, and Tehran Conference, December 1943. These conferences are also related to this sequence only. Okay, now question number 48. Which articles amongst the following were added by 97th Amendment Act of Indian Constitution? 97th Amendment Act came in 2011. Which article was added? Article 243P to 243ZG. This article is related to what? Related to municipalities. Okay, question number 49. In which of the following cases it was observed that Prime Minister and Chief Ministers of the states are subject to the doctrine of constitutional trust? Option A, Subramaniam Swamy versus Director CBI, Manoj Narula versus Union of India, Ashraf Kokar versus KV Abdul, or option number D, Vishwajit Bhattacharya versus Union of India. Then the right answer is Manoj Narula versus Union of India. This case says that the Prime Minister and Chief Minister of the states are subject to the doctrine of constitutional trust. Now question number 50. Auto limitation theory is related to succession, recognition, state jurisdiction, or option D, regarding the basis of international law. Right answer is option number D. Now come to the part 2, that is law. Question number 51. Under Indian Evidence Act 1872, the maxim salus populi supreme lex is related to section 121, 122, 123 or 124. First of all, the meaning of this maxim, that welfare of the people shall be the supreme law. Welfare of people, populi people, should be the supreme law. Okay, and this maxim relates to section 123. Now question number 52. Which of the following sections of Indian Evidence Act 1872 does not deal with the criminal matters? Section 23, 27, 53 or 133. Then section 23 does not deal with criminal matters. All other section deals with criminal matters. Section 23 deals with civil matters only. Next question is, the term judicial notice under the Indian Evidence Act 1872 means notice given by the court, information given to the court to ask for evidence to recognize without proof something as existing. It means to recognize without proof something as existing. The right answer is option number D. Judicial notice means to recognize without proof something as existing. Now question number 54. Court can presume about the legality of digital signature on electronic record under Indian Evidence Act 1872 when it is 30 years old, 15 years old, 5 years old or 12 years old. Then the right answer is 5 years old, and this comes under section number 90A. Now question number 55. Presumption of fact under Indian Evidence Act 1872 is based on logic, human experience and natural events and law of nature. Option B is based on provisions of law, cannot be ignored by law, and option number D is of certain and uniform position. Presumption of fact. Then it is based on logic, human experience and natural events and law of nature. Then option A is the right answer. Now question number 56. The contents of electronic records may be proved under Indian Evidence Act 1872 in accordance with the provisions of which sections? 65C, B, 66B or 66C? Then the right answer of this is 65B. Contents of electronic records. These can be proved in Indian Evidence Act under section 65B. Now 57. Electronic record presented for inspection of the court under Indian Evidence Act 1872 is electronic evidence, documentary evidence, oral evidence or modern evidence. These comes under documentary evidence. Now question number 58. Which of the following is correctly matched according to Indian Evidence Act 1872? Refreshing memory 158, identification parade section 10, admissions 24 or option D, none of the above. Then the right answer of this is none of the above, because refreshing of memory is in section 159, not in 158. And admissions is in section 17, and identification parade is not in 10, it is in section 9. So the right answer is none of the above. Okay. Now question 59. Written document must be proved by writing only. This maxim has been incorporated under which of the following sections of Indian Evidence Act? 87, 91, 121 or none of the above? Then the right answer is section 91. Written document must be proved in writing only. Okay. 60. Where the court has to form an opinion as to electronic signature of any person, the opinion of certifying authority which has issued the electronic signature certificate is fact in issue, relevant fact, proved fact or none of the above. Then it is relevant fact. Section 47A. Okay. Question number 61. Which kind of agreement can be presumed by the court under section 85A of the Indian Evidence Act 1872? Written agreement, oral agreement, electronic agreement or none of the above? Then it is an electronic agreement. Option C. 62. Presumption of dowry death which is mentioned under section 113B of Indian Evidence Act 1872 has been incorporated by the Amendment Act of 1986. Now question number 63. Under the Indian Evidence Act 1872, a declaration made in course of business is admissible under section 32(7), 32(2), 32(4) or 32(1). Right answer is admissible under section 32(2). Next question is, under Indian Evidence Act 1872, the questions relating to a matter not relevant to the suit or proceedings may be asked under which section? Then right answer is section 148. Option C. Question number 65. Which kind of jurisdiction is not mentioned under section 41 of Indian Evidence Act? Probate, admiralty, insolvency or revenue? Then the right answer is revenue jurisdiction. Question number 66. Kaushal Rao versus State of Bombay related with which topic of the law of evidence? This case is related to dying declaration. Option number C is the right answer. 67. Indian Evidence Act 1872 does not expressly mention about oral evidence, documentary evidence, secondary or circumstantial evidence. It doesn't expressly mention about circumstantial evidence. Question number 68. The question is whether A was ravished. The fact that without making a complaint, she said that she has been ravished is relevant as conduct, admissible as conduct, not relevant as conduct, a subject matter of inquiry. Right answer is not relevant as conduct. It is actually an illustration in Indian Evidence Act, illustration J of section 8. Okay, not relevant as conduct. Now question number 69. Where a document is executed in several parts, there each part is a primary evidence of the document. Each part cannot be the primary evidence of the document. Each counterpart is secondary evidence. Only main part is primary while rest is the secondary evidence of the document. The right answer is each part is primary evidence of the document executed in several parts. Okay, so each part will become primary evidence of the document. Now question number 70. Nothing in section 23 of Indian Evidence Act shall be taken to exempt any barrister, pleader, attorney or vakil from giving evidence of any matter of which he may be compelled to give evidence is provided by Indian Evidence Act 1872 under which section? It is mentioned under section number 126. So option D is the right answer. Section 126. Now question number 71. The fact of which the court will take judicial notice under Indian Evidence Act need to be proved, is optional to be proved, need not to be proved, is better to be proved. Then the right answer for this is option C, need not to be proved. The court already has taken a judicial notice, then no need to be proved. Now question number 72. As per preamble of the Indian Evidence Act, the purpose of the act is to provide, define and amend the law of evidence, to provide, consolidate the law of evidence, to define and amend the law of evidence, to consolidate, define and amend the law of evidence. Then the right answer is to consolidate, define and amend the law of evidence as per the preamble of Evidence Act. Question number 73. In criminal proceedings against any person, the husband of or wife of such person shall be competent witness, incompetent witness, competent witness only if they are major and the consent of other, competent witness only if they are sane and with the consent of other. Criminal proceedings are here against any person, husband of or wife of such person shall be the competent witness होंगे. Okay, section number, which section? 120. Now question number 74. A contingent of police led by sub inspector is on patrolling on duty at night. They are attacked by two criminals, in which one constable is severely injured and criminals escaped with their property. Here a case can be made under IPC for an offense of theft, dacoity, robbery or mischief. Then it is the case of robbery. Why? Because there is attack, then there is theft, then it is a robbery, more than one person. Okay, question number 75. Revealing the identity or name of the victim of rape is punishable under which of the following section under IPC? जिस पर्सन का रेप हुआ है, अगर उस विक्टिम का नाम अगर आप बता देते हो या आइडेंटिटी बता देते हो विदाउट देयर कंसेंट, इज पनिशेबल अंडर सेक्शन 228A ऑफ IPC. Now question number 76. Which of the following factors separate robbery from dacoity? Time, property, number or place? A right answer is option number C, number. Separate robbery from dacoity. Okay. Now 77. A gave poisoned halwa Swedish to B with the intention to kill him. B ate one spoon and kept it on the side. C, who was sitting there, picked up and ate it. C dies. Here A is guilty of culpable homicide not amounting to murder. Offense of murder of C. Here A is not guilty of murder as he never intended to kill C, causing grievous hurt. The right option is option number B, offense of murder of C. Okay. So this is basically the case of doctrine of transferred malice, and where is it? It is in section number 301 of IPC. So the right answer will be offense of murder of C. Question number 78. The maxim ignorantia juris non excusat means ignorance of law is no excuse, ignorance of fact is no excuse, ignorance of law is an excuse, ignorance of a fact is an excuse. Non means no. Okay, these two options are already get deleted. Okay, juris means law, ignorance of law is no excuse. Then right answer is option number A. 79. The plea of sudden and grave provocation under section 300 exception 1 of IPC is a question of law, is a question of a fact, a mixed question of law and fact, and or option D, presumption under law. Plea of sudden and grave provocation is question of a fact hai. Okay. Now question number 80. Common intention and similar intention was distinguished in the famous case of Barendra Kumar Ghosh versus King, Mehboob Shah versus Emperor, Kripal Singh versus State of UP, Rishidev Pandey versus State of UP. Common intention and similar intention. Famous case Mehboob Shah versus Emperor 1943. 81. The appropriate government may commute the sentence of death of an accused person to any other sentence with the consent of the accused, consent of relatives of accused, consent of advocate of accused, without the consent of accused. Then it is without the consent of accused. Accused की consent क्यों लेंगे? Where is the term appropriate government is given? It is given in section number 55A of IPC, and commutation the sentence of death is in section number 54 of IPC, and imprisonment for life is in 55. Now question number 82. Necessity as a defense cannot be claimed when the act has been done with good faith, without criminal intent, with inherent risk of causing harm, for avoiding other greater harm. When the act has been done with inherent risk of causing harm. Okay, option C is the right answer. Question number 83. X, who stole jewelry from a jeweler's shop, caused fear of instant hurt. Caused what? Fear of instant hurt to Z, who tried to stop him while carrying away the stolen watch. Here X can be held liable for the offense of extortion, robbery, theft or dacoity. Right answer will be robbery. Now question number 84. Transgender has been recognized as third gender with all rights and a right to reservation by Supreme Court in the case of, it was the famous case of Nalsa versus Union of India. Option C, Nalsa versus Union of India. Now 85. A demand or request for sexual favor from a woman is punishable offense under IPC under which section? 354A. Okay. And what is 354B? Assault or criminal force. and 54C voyeurism, 354D is stalking. Question number 86. Voluntary throwing or attempting to throw acid is an offense punishable under IPC under which section? 326A, B, 228A or 228? The right answer is 326B, throwing acid. Okay. Now question number 87. Which of the following is an offense of continuing under IPC? Continuing nature किसका होता है? Rape, theft, abatement or abduction? Right answer is abduction. Now question 88. The offense of destruction of electronic record to prevent its production as an evidence is punishable under IPC under which section? 201, 4 or 203 or 202? The right answer is 204. Offense of destruction of electronic record to prevent its production. Okay, and what is 201? It is causing a disappearance, and 203 is giving false information. Okay, now 89. The term harbor defined under the IPC does not include supplying a person with shelter, supplying a person means of conveyance, assisting a person to evade apprehension prior to the commission of the offense, facilitating the commission thereof. Right answer is option number D, prior to the commission of offense, facilitating the commission thereof, harbor. And section number 52A. Question number 90. A incites a dog to spring upon Z without Z consent with intention to annoy Z. Here A has committed the offense of criminal force. This is actually an illustration. Illustration H hai, section 350, criminal force. 91. A police officer tortures Z in order to induce Z to confess that he has committed a crime. Here A is guilty of which offense? A is guilty of causing hurt to extort confession. 330. Illustration A, causing hurt to extort confession. Question 92. Which of the following sections has been inserted in the IPC by the Criminal Law Amendment Act 2013? Section 376A, B, 166A, B or 354C or option D, all of the above. Then D है इसका right answer. All of the above sections were inserted under Amendment Act 2013. Question number 93. The right of private defense does not extend to cause death of the offender in which of the following offenses? Rape, kidnapping, gratifying unnatural lust or causing miscarriage. The right answer is causing miscarriage. In all the other three cases, if the person in private defense can even cause the death of the offender. Okay, rape is in section 376 and kidnapping 359, 60, 61. Gratifying unnatural lust is 377. 94. When a woman was taking bath in her bathroom, X captures the image in his mobile and upload it on her Facebook page. What offense has been committed by X? Sexual assault, insulting the modesty of a woman, voyeurism or stalking? Then a right answer is voyeurism. Clicking of pictures without the consent of that person, then it comes in voyeurism. Next is question 95. Which of the following is not a sine qua non for making a person criminally liable? Sine qua non is a Latin term which means that without which not. Or it can be said that something which is necessary or indispensably required. Okay, option number A is actus reus, that is criminal act. Or option number B, mens rea, evil or guilty mind. Option C, motive. Or option D, all of the above. Then the right answer for this is option number C, motive. Now question number 96. A under the influence of unsoundness attempt to kill B. B in attempting to defend himself caused grievous hurt to A. Here option A is liable for attempt to murder and B is liable for causing hurt. Option B, A commits no offense and B is liable for grievous hurt. Option C, B commits no offense and A is liable for attempting to murder. Or option D, both A and B are excused from the liability. Then the correct answer is option D. Both A and B are excused from liability. How? A from the unsoundness of mind, because he is of unsound mind, and B because of right to private defense, section number 98, and unsoundness of mind is in section 84. 97. Statements under section 161 of CRPC are recorded by police during trial, before investigation, during inquiry. Then it is during investigation. Next question is under section 190 of CRPC 1973, cognizance of offense is taken by a judicial magistrate, session judge, high court or district magistrate. It is judicial magistrate. In section 190, cognizance is taken by judicial magistrate. Now question 99. During the trial, statements of an accused person are recorded by the court under CRPC. Under which section? It is section number 313. Statements of accused person are recorded by the court. And in section 311, court can call the witness. And section 312, expenses of complaints and witnesses, and section 314 is oral arguments or memorandum of arguments. Okay, now question number 100. Under CRPC, charges may be added or altered under which section? Section 216. And what is in section 211? Contents of charge. 212 is particulars as to time, place or person. Okay, and section number 215 talks about effect of errors. So the right answer is 216. Charges may be added or altered. Question number 101. Under CRPC, in a warrant case instituted on police report, the trial begins when the charges are framed, accused appears, witnesses are examined, or none of the above. The right answer is charges are framed. Okay. 102. In which of the following trials under CRPC, hearing of an accused on sentence is not necessary? It is a summons case. In trial of summons cases. Okay. And which section? Section 251 से लेकर 259. Question number 103. A commits robbery on B and in doing so voluntary causes hurt to him. Whether A may be separately charged under section 323, 392 and 394 of IPC. The right answer is yes, he can be separately charged. Question number 104. Criminal Law Amendment Act 2013 came into effect on which date? It came into effect on 3rd February 2013. Question number 105. Any dispute relating to the possession of immovable property under CRPC is decided by whom? By executive magistrate. Section 145, say 147. Question number 106. An accused person may be a competent witness in his own defense under CRPC in which section? Section number 315. Next question. The classification of offences has been given under CRPC under which section or schedule? The classification of offences is in schedule 1. Next is question number 108. Section 91 of CRPC does not apply to complainant, witness, accused, a person who is neither a complainant or accused or witness. The right answer is on accused. It does not apply to accused. 109. A person can be summoned as a witness under 160 of CRPC by whom? By the police officer who is investigating the case. The right answer is option C. Next is question number 110. Under which section of the CRPC a district magistrate or subdivisional magistrate may prevent environmental pollution? Environmental pollution. It is important question. It is under section 133. Right answer is option number B. Next question number 111. Treatment of a victim has been incorporated under CRPC by Criminal Law Amendment Act under which section? The right answer is 357C. And what is in 198B? It is a cognizance of offense. No court shall take cognizance of an offense punishable under 376B of IPC where the person are in marital relationship. And what section 357B talks about? It is compensation to be in addition to fine. With the fine plus the compensation is added to that. Now question number 112. In a FIR, an offence is cognizable and other is non-cognizable. The whole case shall be deemed as cognizable. Section number 155. 4. Now the next question is question number 113. Which of the following cases statements are true? State government shall establish a court of session with consultation of High Court, or state government shall establish a court of session. Right answer is B, the statement B, state government shall establish a court of session, section 9(1). Next question, the provision of CRPC 1973 other than those relating to chapter 8, 10 and 11 thereof shall not apply in which of the following: state of Tripura, Assam, Meghalaya or Nagaland. It does not apply to state of Nagaland. The next question is question number 115. Under Code of Criminal Procedure 1973, a charge shall be written in the option A, language which the accused understand. Option B, the language which the witness understand. Option C, the language of the court. Or option D, the Hindi language. The right answer is option number C, language of the court. And where it is provided under section 211, subsection 6 of CRPC. Next is question number 116. What is the maximum default sentence that can be awarded in case of non-payment of compensation under section 358 of Code of Criminal Procedure 1973? Option A, 60 days, B, 30 days, C, 90 days, or option D, 120 days. The right answer is option number B, 30 days. And where it is provided? It is provided under section 358 subsection 3 of CRPC. Now next is question number 117. An order passed by a magistrate under section 446 of the Code of Criminal Procedure 1973 is appealable to whom? Option A, session judge, B, district magistrate, C, high court, or option D, Supreme Court. So what is there in section 446? It is the procedure where bond has been forfeited. So the right answer is option number A, session judge. And where it is provided? It is provided under section 449 of CRPC. Next is question number 118. If a person against whom an order under section 133 of a Code of Criminal Procedure 1973 is made appears and show cause against the order, the magistrate shall: option A, take evidence in the matter as in summon case. Option B, take evidence in the matter as a warrant case. Option C, take evidence in the matter as an extraordinary case. Or option D, take no evidence. Take the evidence in the matter as in a summons case. It is actually provided in section 138 subsection 1 of CRPC. So the right answer is option number A. Okay. 119. Which of the following is not an essential procedural requirement of 164 of CRPC? Warning to the accused, confession to be made voluntary, recording of the statement in presence of the advocate of the accused, or memorandum at the foot of confession. The right answer is C, recording the statement in presence of advocate of the accused. Now 120. Which section of CRPC provides for confirmation by the High Court an order of death penalty passed by Session Court prior to its execution? Is section 368. Next is question number 121. The term res sub judice means stay of suit, stay of appeal, stay of application, or stay of execution. It is stay of suit. Res sub judice. Section number, which section? Section 10 of CPC. Next is question number 122. Under section 100 of CPC, second appeal lies to the High Court only on the ground of what? Substantial question of law. Option B. Next question, question number 123. Which of the following person may not file an application for execution under CPC, namely a decree holder, legal representative, if the decree holder is dead, a person claiming under decree holder, or the fourth is judgment debtor? Right answer is judgment debtor. 124. Who may apply for reference under 113 of CPC? A party to the suit, court, both A and B, or none of the above? The court. Next question. It is a statement of a claim, a document by presentation of which the suit is instituted, is called an affidavit, written statement, counterclaim, or plaint. It is called as plaint. Affidavit is in order 19 and counterclaim is order 8, 6A. Written statement is order 8. Plaint is order 7. Question 126. Order 42 of CPC deals with what? Appeal to Supreme Court, appeal to indigent persons, appeal from appellate decrees, or appeal against orders. Order 42. Then it is appeal from appellate decrees. 42. Okay, 127 is which one of the following provision of CPC is related to affidavit? Or order 19 is affidavit, earlier I told you, and order 17 is adjournment, order 26 is commissions, and what is order 39 is temporary injunction. Okay. Question number 128, under which provision of CPC a plaint is rejected by the court in absence of cause of action? Order 7, Rule 11A, B or D or C? Right answer is order 7, Rule 11A. Next is question number 129. A caveat shall not remain in force after the expiry of days. It is option C, 90 days of its filing. 90 days. Now question number 130, under which provision of CPC attachment before judgment is provided? It is provided under order 38, rule 5 to 13. Question number 131, execution of decree for specific performance for restitution of conjugal rights or an injunction is provided under CPC, and which order? It is provided under order 21, rule 32. Specific performance for restitution of conjugal rights. 132. Maximum amount which a court may order for payment of compensatory cost in case of false or vexations, claims or defenses under CPC is how much? It is 3,000 rupees. Option B mentioned in 35A. So, now question number 133, a garnishee order under CPC is issued to whom? It is issued to judgment debtors, debtor. Order 21. And what is in 46A? It is notice. Now 134, which of the following order of CPC is related to set off and counter claims? It is order 8, set off and counter claims. 135, which of the following is not correctly matched according to CPC? Legal representative section 50, notice 80, letter of request 77, or res sub judice 11. Right answer is D. Res sub judice is not in section 11, it is in section 10. 11 is res judicata. 136, CPC Amendment Act 2002 was enforced from 1st July 2002. 1st July. Next is question number 137. During the proceedings for execution of a decree, if a question arises as whether any person is or is not the representative of a party, such question must be determined by option A, the court which passed the decree, option B, the court executing the decree, option C, appellate court, and option D, none of the above. Then the right answer is option B, the court executing the decree, and it is mentioned under section 47 subsection 3. Next is question number 138. Supplementary proceedings under section 94 of CPC does not include arrest before judgment, attachment before judgment, temporary injunction. Injunction का spelling mistake है. And D, appointment of executor. Right answer is appointment of executor, section 94. Now question 139. Under CPC, foreign court means what? A court situated outside India and is not established under the authority of government of India, court situated in India applying foreign law, or all of the above. The right answer is option B. The court situated outside India, not established under the authority of government of India, is a foreign court. And where is the definition of foreign court? It is mentioned under section 2 clause 5. Question 140. Guardian ad litem used under CPC means a local commissioner, court, a person defending a suit on behalf of insane person, a person defending a suit on behalf of a minor. It is option D, suit on behalf of a minor, mentioned under order 32, rule 3. Next is 141. Under which of the following section of Hindu Marriage Act 1955 divorce by mutual consent has been provided? Divorce by mutual consent is in section 13B. 13A is alternative relief, 11 is void marriage, and 15 is divorced person may marry again. Okay. 142. In which of the following reports the Law Commission recommended the breakdown principle to be accepted as additional ground for divorce? It was given under 71st report. Breakdown principle. It is an additional ground for divorce. 143. When a child of opposite sex is proposed to be adopted, the adopter must be senior to it in age by at least 21 years. Section 11. The difference should be of 21 years. Question. Under Hindu Adoption and Maintenance Act 1956, mandatory requirement for adoption of a child is giving and taking. Right answer is option A. Now question number 145. Which of the following is not a ground for divorce under Hindu Marriage Act 1955? Insanity, leprosy, epilepsy or venereal disease? It is epilepsy. Otherwise, insanity, leprosy and venereal disease are ground for divorce. 146. According to court rulings, custody of a Hindu child up to the age of 5 years shall ordinarily be with the mother. 6A. Section 6A. Question 147. During the pendency of appeal against the decree of divorce, the parties are competent to solemnize the second marriage, may contract another marriage with the leave of the court, are not competent to contract another marriage and their incapacity to do so is absolute or none of the above. अभी अपील में पेंडेंसी है डिवोर्स की डिक्री, देन राइट आंसर इज ऑप्शन सी, नॉट competent to contract of another marriage. Now question 148. A boy of 16 years of age may validly be taken into adoption by law by contract between the parties by consent of the father of the child, or option D, if the customer, यहाँ spelling mistake है, it is not customer, it customs usage applicable to the parties so permits. The right answer is option D, permits, and it is mentioned under section 10 clause 4. Question number 149. Lakshmikant Pandey versus Union of India, AIR 1984, Supreme Court lays down the rule regarding inter-country adoption. Lakshmikant Pandey versus Union of India, inter-country adoption का केस है. Registration of marriage has been made compulsory by Hindu Marriage Act 1955 under section 8. रजिस्ट्रेशन ऑफ मैरिज इज सेक्शन 8. और केस कौन सा इसका? सीमा वर्सेस अश्वनी. क्वेश्चन 151. सेक्शन 14 ऑफ हिंदू मैरिज एक्ट 1955 imposes a ban for filing the petition, ban on filing the petition for divorce. 152. Every appeal from decrees or orders under section 28 of Hindu Marriage Act 1955 shall be preferred within how many days from the date of decree or order? Is within 90 days. A. Who is the natural guardian of a married minor girl? Married minor girl. Natural guardian is husband because she is married. Section 6C. 154. In which of the following ceremonies is or are obligatory under Hindu Marriage Act 1955 for a valid marriage? Valid marriage is customary rites and ceremonies of either party. Customary rites. Option C is the right answer. 155. Children born out of void or voidable marriage under section 11-12 of Hindu Marriage Act are deemed to be legitimate but can inherit the property of their parents only. Whether the marriage is void or voidable, children are always considered as legitimate. Now 156. A divorced Hindu wife can claim maintenance under which of the followings? Under Hindu Marriage Act only, Hindu Marriage Act and Criminal Procedure Code 1973, Hindu Adoption Maintenance Act and Hindu Marriage Act. Right answer is in all of the above. She can claim the maintenance. 157. Rules relating to Sapinda relationship are based on the principle of exogamy. Sapinda exogamy. The breakdown theory of divorce is reflected in which section of Hindu Marriage Act? Breakdown theory is 13(1)(a). Section 159. The petition for divorce by mutual consent may be presented according to Hindu Marriage Act 1955 if the spouses have been living separately for a period of 1 year. 160. The property of Hindu woman dying intestate shall devolve firstly upon whom? Firstly upon sons and daughters and the husband. Section 15. 161. Contingent interest in the property becomes a vested interest on the happening of an uncertain event, or the happening of an event becomes impossible. या तो uncertain हो or impossible. 162. Section 12 of TPA is not applicable where the transfer is by the way of lease. Okay, applicable only by the way of sale or exchange or a gift, not by the lease. Next is 163. Which one of the following section of TPA deals with the direction for accumulation? Section 17. Next is question 164. Transfer of ownership of immovable property in exchange for a price paid or promised or partially paid or partially promised is called what? Is called sale. Section 54. 165. Section 56 of TPA deals with what? Section 56 of TPA deals with, right answer is option A, marshalling by subsequent purchaser. Question number 166. If the donee dies before acceptance of a gift, the gift is what? The gift is void. 122 section. Next is 167. Chapter 7 of TPA does not apply to transfers of property under Christian law, Parsi law, Mohammedan law or Hindu law. Under Mohammedan law. Section number 129 of TPA. And question number 168. Which one of the following is not a ground for determination of a lease? Is not a ground. Refuse of the time limited, implied surrender, expiration of notice of determination of lease, or death of the lessee. Right answer is death of the lessee. 169. Which one of the following is not an essential condition for the application of the rule of less pendants under section 52 of TPA? Not an essential condition. What is not an essential condition? Options देख लेते हैं. Pendency of a suit or proceeding, pendency in a competent court, suit must be collusive, or alienation must affect the rights of the other party. Then the right answer is, no, which is not an essential condition, is option D. Alienation must affect the rights of other party. Now next question. Next is 170. Find out the incorrect answer from the following. Gift is the transfer of ownership without consideration. Yes. 122. Gift should be accepted during the lifetime of the owner. If the donee dies before acceptance, the gift is void. The gift may be made only of movable property. Incorrect is option D. Gift can be made of either kind of property, movable or immovable. Next is 171. TPA came into force on 1st July 1882. Question 172. According to section 5 of TPA, the term living person includes whom? A human being only important company or associations of or body of individuals, or none of the above. Living person includes company or association or body of individuals also. Next question. Which one of the following condition is invalid according to section 10 of TPA? A condition not to sell outside the family, condition not to sell during the lifetime of the transferor, not to sell to a person of different religion, restraining subletting of leased property. Right answer is option B. A condition not to sell during the lifetime of the transferor. Okay. Question 174. Which one of the following is not an essential condition of section 43 of TPA? The representation must necessarily be fraudulent. Transferor makes a representation that he is competent to transfer. Transfer is of immovable property. Transfer is for consideration. The right answer is first. Representation must necessarily be fraudulent. Next question. Once a mortgage, always a mortgage means mortgager has no right to assign right of redemption to any person. Mortgagee has no right to assign the mortgagee debt to any other person. Mortgage cannot be redeemed after the expiry of the fixed period, or option D. Mortgage is always redeemable. His right answer is D. Always redeemable. 176. Section 122 of TPA deals with which of the following kind of gifts? Namely, gift inter vivos, moritis causa, gift by will, or all of the above. The right answer is A. Gift inter vivos. Question 177. Which one of the following section provides the statutory duties of mortgage in possession? 77, 78, 79 or 76? The right answer is section 76. Statutory duties of a mortgage in possession. And what does section 77 tells? It is receipts in lieu of interest. Okay, and 78 is postponement of prior mortgage, and 79 is mortgage to secure uncertain amount. Next question. The provisions relating to onerous gift have been provided under TPA in which section? Onerous gifts is provided in section number 127, option A. And 125 is gift to several. And what does 124 say? Is gift to existing and future. And 126, when gift may be suspended. Now next question. 179. The Transfer of Property Amendment Act 2003 has amended which one of the following sections of Transfer of Property 1882? Section 107, 106, 108 or 100. Amended which section? It has amended section 106. What was the amendment? The amendment was related to duration of the lease. Next question, question 180. The transferee of an actionable claim shall take it subject to all the liabilities and equities and to which the transferor was the subject in respect thereof. At the date of the transfer, before the date of transfer, after 15 days of the date of the transfer, or before 15 days of the date of the transfer. Right answer is option number A, at the date of the transfer. Section 132. 181. Section 52 of Transfer of Property Act does not apply to pre-existing rights. And rest of them it applies. 182. Under which one of the following schools of Muslim law muta marriage is recognized? It is recognized in Itna Ashari school. Next is 183. Where the person who performed nikah is dead, the proof of marriage will be given by the witness. Next question. 184. A Muslim widow remarries during the period of iddat. The marriage is fasid. Next is 185. Musha under Muslim law means what? Musha, an undivided share in the property. Right answer is option A. 186. Under Muslim law, a bequest can validly be made to a child in womb so long it is born from the date of a will within the period of how many months? 6 months. Option B. Next is 187. Creating a waqf means dedication of property to whom? To the God. Next is 188. Shariat Act 1937 contains only how much sections? 6 sections. B. 189. According to Hanafi law, a mother is entitled to the custody, hizanat, of a male child till the age of how many years? 7 years. Next is 190. Khiyarul bulugh means option of puberty, a form of dower, a form of valid marriage or infidelity. Khiyarul bulugh is option of puberty. Option A. 191. Dissolution of Muslim marriage in 1939 specifies certain grounds of divorce which are available to whom? To wife only. 192. In which of the following cases the Supreme Court has recognized the validity of adoption of a child even by a Muslim? Is option A. Shabnam Hashmi versus Union of India and others. 193. A Muslim wife's right to dower can be claimed as preferential debt, ordinary unsecured debt along with other creditors, an ordinary debt with but priority over other creditors, a secured debt. Right answer is option B, ordinary unsecured debt along with other creditors. 194. How much time of abstinence is required in ILA form to enforce the dissolution of marriage under Muslim law? Abstinence of how much months? 4 months. Right answer is option C, 4 months. Next is 195. Under Muslim law, the term fasq is used to denote restitution of conjugal rights, dissolution of marriage by judicial decree at instance of husband, judicial separation, dissolution of marriage by judicial decree at instance of wife. Is the fasq is dissolution of marriage by the judicial decree at the instance of wife. Fasq. 196. Under Muslim law in the matter of a marriage, if there is a conflict between the views of minor and the guardian, the law will give the priority to whom? To the guardian. 197. A sick man makes a bequest and being unable to speak from weakness gives a nod with his head and he dies without regaining the power of speech. The bequest is what? Is void, irregular, valid, or none of the above will be considered as valid. 198. A right of divorce by lien is available to the wife when the husband accuses the wife of what? Of adultery. 199. In the Hasan form of talaq, the talaq is effective from the moment of pronouncement on expiration of iddat period on the third pronouncement from the execution of writing of talaq nama. The right answer is Hasan form. कौन सी होती है? On the expiration of iddat period. 200. In which of the following case the Supreme Court has held that the 3 talaqs would be treated as a single talaq and not a valid talaq? Which case? Shamimara versus State of UP, AIR 2002. Now with this our 2014 Uttarakhand judiciary paper is completed. In case of any doubt, you can always ask in the comment section given below. Thank you so much for watching this video.